I declare the meeting open to the public. Can I advise members that the committee meeting will be recorded and broadcast throughout Parliament buildings and online? And can I advise members and those in the public gallery that they are welcome to use mobile devices as long as they are on airplane mode and all devices are muted. Attendees can also connect to the Assembly Wi-Fi and password details are available on the gallery rolls. It is not permitted to take photographs or record any part of the meeting. Can I advise members that it is proposed that the oral evidence session with departmental officials on the victims and witnesses of crime strategy and the session on the SL1 for PACE will be recorded by Hansard? And can I seek members' agreement to this? Agreed?
Agreed.
Can I remind members that they are obliged to declare any financial or other relevant interests that might reasonably be thought by others to influence their approach to the matters under consideration? Any members who have interest to declare in relation to today's business should do so now or when the particular matter arises. Can I ask members if there are any interests? No. Okay. Agenda item number 3 then is draft minutes. Can I inform?
Sorry, Chair.
So go on ahead.
Sorry, Chair. Just under correspondence, there's correspondence there from the Committee for Finance. I'm a member of that committee.
Okay, no problem. Agenda item number 3 then is draft minutes. Can I inform members that draft minutes of the meeting held on Thursday 19th of February 2026 are at pages 13 to 23 of the meeting pack? Can I ask members if they are content that the minutes are a true reflection of the proceedings of that meeting held on the 19th of February? If so, I will sign. Agreed?
Agreed.
There you go. Thomas. Okay, agenda item number 4 then is matters arising. Can I remind members that at last week's meeting, members noted that the examiner of statutory rules had advised that she would formally report on the technical aspects of statutory rule 2026/11, the payment and electronic money institution insolvency Northern Ireland rules 2026 in her next report, but had indicated in advance to members that it will not be required to be drawn to the special attention of the Assembly. Can I inform members that the examiner's report is at pages 25 to 32 of the meeting pack, and as advised, the rule is not required to be drawn to the attention of the Assembly. 4.2 then, draft response to Committee for Finance on the Department of Justice proposed draft budget for 2026-27 to 28-29-30. Can I remind members that at the meeting on the 22nd of January, the Committee considered correspondence from the Finance Committee seeking views on the Department of Justice allocation in the Finance Minister's draft multi-year budget. Members agreed that the committee staff would prepare a draft response for the committee's consideration following the oral evidence session with the Justice Minister and then last week's session with departmental officials. Can I inform members that a draft response is available for members at pages 9 to 21 of the tabled pack? Can I ask members if they are content with the draft response or if they wish to propose any amendments? If not, then can I seek members' agreement to issue the draft response to the Finance Committee, subject to any amendments that members agreed to make? Agreed. And can I seek members' agreement to forward a copy of the response to the Department of Justice for information? Is that agreed? Yeah. Can I remind members that at last week's meeting the committee considered a number of items of correspondence regarding Kiva's law and agreed to write to the department. The department has requested sight of the Minister of Infrastructure's letter on this matter that had been forwarded by the Committee for Infrastructure. So can I seek members' agreement to forward to the Minister of Infrastructure's letter to the department for their information? Agreed?
Agreed.
Can I ask members if there are any other matters arising from the minutes that they wish to raise at this stage? No. Okay. Agenda item number 5 then is Victims and Witnesses of Crime Strategy 26 to 32, Department of Justice Oral Evidence. Can I refer members to pages 34 to 167 of the meeting pack for the relevant papers? Can I inform members that the committee will receive oral evidence from Department of Justice officials on the new Victims and Witnesses of Crime Strategy 26-32 with integrated performance framework and initial 2-year action plan? Can I inform members that the officials providing oral evidence today are Julie Wilson, Deputy Director of Victim Support Division, Emma Crozier, Head of Victim and Witness Branch, and Joanne McDermott, Deputy Principal, Victims and Witness Branch. You're very welcome to the committee. So can I invite you to make an opening statement, Julie, if that's okay?
Yes, thank you. Thank you, Chair and committee members. We're grateful for the opportunity to speak today and welcome the opportunity to outline the context, the ambition and the operational direction underpinning the strategy. The strategy represents a significant cross-system commitment to improve the experience of victims and witnesses who come into contact with the criminal justice process. It's been defined not only by policy objectives but by the voices, the stories and the lived realities of victims and witnesses across Northern Ireland. So before I turn to the detail, I'd like to acknowledge those who have given their time to respond to the various stages of consultation, but also those who have fed back their experiences directly to the Minister or through surveys and other means. All of this has helped to shape the strategy. The strategy reflects the views from a wide range of backgrounds, perspectives and experiences, and we believe that it's resulted in a better strategy and more relevant and effective actions included in our delivery plan. There's also been extensive collaboration with partners across the criminal justice system and with community and voluntary sector organisations who all have key roles to play in supporting and enabling the delivery of a justice system that ensures that victims and witnesses are shown respect, courtesy and sensitivity, and that they're offered the support that they need to help them as they journey through the system. As I've said, one of the most important elements of this work has been hearing the views of victims and witnesses during the call for views and during the public consultation. The comments received were honest, powerful and often uncomfortable to hear, particularly where they highlighted gaps or failings in the system. So some of the feedback included, one of the biggest problems for me was having to keep chasing the police for updates. Communication should be helpful communication, not just leaflets. The language used was flowery, which makes it difficult for a layperson to understand. Trauma can often present absorption of new information. I didn't have a clue what was supposed to be happening. So these are powerful statements, but they're not isolated comments, and they are reflective of issues that we have been aware of, that we've been grappling with for many years. And progress has definitely been made under the last strategy. But despite this progress, we recognise that many victims still feel lost within the process, unsure of who they need to speak to when decisions will be taken and why certain outcomes occur. And what we want to do through this strategy is address those persisting challenges. So this strategy places the voice of victims and witnesses at its centre, not just in its development, but also in its delivery. So we've consulted before as we've been developing the strategy. Our intention is to continue to engage with victims and witnesses as we develop the policies and services and interventions under the strategy. The need for the strategy is clear. Crime harms individuals, families and communities in ways that can often be long-lasting, deeply personal and invisible. Those who become victims or witnesses don't choose that role, yet they are essential participants in the justice process, and the justice system needs to meet them with professionalism, compassion and respect at every stage. The strategy aims to address three important realities. First of all, that the impact of crime is wide-ranging. It affects physical, emotional, psychological and community well-being. Secondly, that experiences within the criminal justice system can compound and have compounded trauma where support and communication are insufficient or inconsistent. And finally, that confidence in the justice system is directly linked to how victims and witnesses feel that they are treated, whether their rights are upheld and whether the system is transparent, timely and fair. So outcomes do matter to victims, but so does the journey and the process that they need to go through. The strategy covers a lifespan of 6 years, and this is because meaningful systemic change is an ongoing, evolving process, and it takes time and it cannot be delivered by any single agency working in isolation. The strategy has been built on 4 key principles. First, it's informed by victims and witnesses, including children. Their voices, as I've said, have shaped the work, the priorities and the performance, and we believe that has very much enriched the strategy. Second, it relies on partnership. The justice system is complex with independent but often interdependent organisations, including law enforcement, legal professionals, voluntary sector partners, as well as associated organisations that have a role in monitoring, inspecting, handling complaints, and a commissioner designate for victims of crime. So a partnership approach is essential to delivering a joined up and streamlined response that victims and witnesses can experience as a single cohesive system rather than fragmented and disoriented, which is what we often hear. The third principle is about trauma-informed practice, and this underpins everything that we're seeking to achieve within the strategy. It's the key approach that our engagement and feedback has told us will transform the experience of victims and witnesses in the justice system. Fourth is about research and best practice, and we will seek to maintain close links with our local academic institutions and research bodies to make sure that we can avail of evidence-based reports and recommendations. Also close contact with neighbouring jurisdictions to share experiences and identify best practice. We'll also develop improved data capture systems to monitor how well we uphold charter obligations and to capture victim feedback on their experiences in the system. So these 4 principles in turn underpin the 5 pillars of the strategy. Support, which obviously is about ensuring that victims and witnesses have access to timely, tailored and effective support services at every stage. And we will achieve this through actions such as the development of a new victim needs assessment service, reviewing the provision of referral pathways between police and victim support, continuing to fund existing support services, establishing systems to gather data and evidence about victim and witness experiences, as I've mentioned. Pillar 2 is about communication and information, and obviously from the comments and feedback that I read earlier, this is a really fundamental issue for victim confidence. So this pillar is intended to ensure that victims and witnesses will receive timely updates, clear explanations, accessible information and communication that is presented in a trauma-informed way. Pillar 3 is about transparency and participation. It's about being open and clear about the stages of the criminal justice system and the decisions made that impact on victims and witnesses. So in practical terms, this is about better information about the decision-making process and reasoning, supporting victims and witnesses to have their voices heard, exploring alternatives to prosecution where that's appropriate, and strengthening special measures. It will include a review of the use of victim personal statements, and it will also seek to ensure that information about potential alternatives to prosecution, including restorative justice practice, is included as part of any future revision of the victim and witness charters. It will also ensure that those who are given leave by the court are offered the use of remote evidence facilities, and we will explore how to expand the existing facilities. Pillar 4 is about rights and confidence, about improving public confidence in the justice system by consistently delivering the services and standards that we are obliged to under the victim witness charters, and we know that we don't consistently deliver those. So in support of this, we are, as the committee is aware, we intend to establish a new office, Statutory Office of Commissioner for Victims and Witnesses of Crime. We plan to legislate for criminal justice organisations to report on and demonstrate charter compliance. And we plan to increase opportunities for the voices of victims and witnesses to be heard, including through the publication of survey results. Finally, Pillar 5 focuses on children and young people. It's about ensuring that their specific needs are taken into account and that the system is adapted to deliver against those needs. So we plan to focus on child-centred, age-appropriate and trauma-informed support, progress towards a Barnahus-informed model, and ensuring that the views and issues raised by children, young people, parents and carers, that they're sought, that they're listened to and that action is taken. We'll also look to see how we can move the existing CSOLA, Children's SOLA pilot, from a pilot to mainstream services, and we will build on existing plans to pilot pre-recorded cross-examination. How we engage children and young people is really important, and we plan to develop a bespoke children and young people model for gathering feedback and create a children and young person version of the strategy document. We know that many communities and cohorts of victims and witnesses have highlighted barriers to reporting and barriers to staying engaged and accessing support. This is intended to be a strategy for all victims and witnesses of crime, and we want to ensure that the support that is delivered under this strategy is tailored to individual needs, and we want to deliver a strategy that will allow victims to feel safe and listened to. Our action plan sets out the ways in which we want to increase opportunities for the voices of victims and witnesses to be heard. This includes direct engagement with representative bodies, including rural and minority communities and disability organisations, in developing future policy and delivering operational change. To ensure credibility and delivery, the strategy includes a 2-year action plan with further plans that will follow, a comprehensive performance framework, oversight by the Victim and Witness Steering Group, a central role for victim champions, transparent progress reporting, and increased data collection across the system. Every action has a responsible owner, every outcome has a measurable indicator, and we want to ensure that this is a strategy that will deliver. Many respondents emphasise that improvements are not possible without investment, and we recognise that. However, funding pressures are real, as the committee will be aware, and they remain challenging. And to manage these, we intend to prioritise those actions that will deliver the greatest positive impact to victims and witnesses. We will continue to make the case for sustainable and multi-year funding for support services and for the delivery of this strategy. So in conclusion, this strategy represents a commitment and a challenge. A commitment to improving the experiences of victims and witnesses, and a challenge to do better as a system, consistently, compassionately and transparently. We owe it to victims and witnesses to ensure that their engagement with the criminal justice system doesn't deepen their trauma nor diminish their confidence in justice. We want to have a system that empowers, supports and protects those who need it most. Chair, we're happy to take any questions.
Okay, thank you very much, Julie, for your presentation there and for your presence here today on this very important issue with regards to the strategy and the updating of that. And of course we have the Victims and Witnesses of Crime bill that's coming before us, hopefully very soon. Do we have a date for that bill?
We're aiming to introduce before June, but work is ongoing on instructions and on drafting at the minute.
Okay, thank you. With regards to your actual tables of pillars, I can see a trend appearing here as I sift through it, and that is basically the terminology which says cost to be confirmed, and it's threaded right throughout the strategy. So how can you then, with all seriousness, bring a strategy to this committee and actually roll it out when it hasn't been costed?
So some of the measures within the strategy and the action plan have been costed. Some will need preparatory work and scoping work for us to identify what those costs will be. So when it comes to things like the Victim Needs Assessment Service, we have done some of that preparatory work, and we have a bid currently with the Transformation Fund for that. So there are some things where we do need to do more preparatory work, and that preparatory work is part of what we intend to do under the action plan.
So how do you see this strategy playing out if you can't identify costs? Your finance team won't then be able to identify costs, but yet you have to provide the executive with costings of what your budget will look like for the next 3 years. Now I'm talking about the whole budget for the whole department, but if you're still left with blind spots in this strategy, how are you ever going to bid for the appropriate amount of funds?
For the things that we would hope to make operational under the action plan, and some of the things that we're working on under the action plan, the preparatory work is going to fall in those first 2 years, and delivery and cost is likely to follow then in years 3 or 4. So it is an evolving. It's an evolving strategy. The first 2 years are not purely about scoping. Some of it is about delivery as well. Where we have those costs and where we're in a position to deliver, we will. And the bids that we make are evolving as well. So we're constantly kind of highlighting where we want to bring forward new services and what that will mean in effect. So we don't have I guess what I'm saying is we don't have a full picture, but we do have parts of that picture, and where we know that we are bidding for that funding.
I suppose it begs the question, if you don't know the full picture, how will anybody else in this sector that's affected by your strategy?
With respect, and I mean that respectfully, not cheekily. We have been focusing on development of this strategy with the intention of bringing forward programmes of work to then realise that ambition. So we've always been aware this is going to take time. It's a 6-year strategy. We don't know the full costs for that whole strategy, and we also don't know if, being realistic, we also don't know what funding we will receive. We will bid as those costs are identified, but we do need to be looking at options. So, for example, that Victim Needs Assessment Service, we've done some initial early scoping, but there is a piece of work to look at how that Victim Needs Assessment Service will dock into some of the services that already exist. And we need to do that piece of work in order to show due diligence and make sure that we're not duplicating other work, and make sure that what we'll end up with is a system that is cohesive, that makes best use of public funds. So that is complicated, and it does take time to do. So I think there is no way that we could have produced a strategy and have done all of the costings in advance. So it will evolve.
I'll give you an example. So one of the action points is to legislate to improve victim experience through the establishment of a statutory commissioner for victims and witnesses of crime. We already have an interim commissioner for victims and crimes who is pretty much operational, but yet you have not costed that.
That work is ongoing. There's a business case which is currently being prepared. We weren't in a position to put it into the strategy at this point, but it doesn't mean that the work isn't very well advanced, and we can write with further detail on that, but it's not in the strategy because it is an ongoing piece of work. We are progressing on multiple fronts, so it's the same team that's working on that, that's worked on this, that's working on the bill, and we're progressing pieces of work in parallel and in tandem. So we haven't had all our ducks in a row before we've moved on to the next stage.
How much has the interim commissioner cost us?
I don't have that information in front of me, but I can write to you with that. The costs of the interim commissioner will help to inform the costs of a statutory commissioner, but there will be other functions, etc., which need to be costed. So there's a lot of thinking that has been done, but we haven't got the final costs yet.
Okay, thank you. Doug?
Yeah, sorry, thank you, Chair. Julie, thank you for that presentation. Look, I'm going to be really honest. I've been banging my head on so many occasions in regards to victims and witnesses, because when I think of victims and witnesses, I think of them from the moment they became a victim or a witness, they've taken them through the criminal justice system right up to trial and post-trial as well. But in order for them to get all of the information you're talking about, communication and information, am I right to say that they have to sign up to the Victims Information Scheme?
No, the Victim Information Scheme is very specific about and is a scheme that's set in statute. What we're talking about here in terms of that information is information about your ongoing case, your information about what's happening in the investigation at appropriate times in line with what different organisations are required to provide under the charters. So it's about, so when I'm saying about improving how we inform and improving how we communicate. It's about making sure that there are timely updates. It's about engaging with victims at the right time to understand, well, what are their needs in terms of a trial date, when's their availability, be clear about changes to the process, also about the language with which different organisations may communicate or write out. So it's that level of information and communication. Victim information schemes are operated by Prison Service and Probation Board, and they're about victim information schemes about the offender. So that is different, and they do need to register for those.
And therefore, your whole scheme that you're putting out to us now is up to the time of conviction, then it stops, that's what we're saying, and then after that it moves on to something else? Or are you sweeping through? Because it seems very strange to me that, a victim and a witness doesn't stop being a victim and a witness the moment the trial is over. They remain victims and witnesses. Yet what we're talking with this strategy here, and what you've just said to me is, well, once the trial's over, if they don't sign up to the victims information scheme, they're not going to get any more information because it's now post-trial. That doesn't.
I think there's also
doesn't sound coherent or joined up to me.
I think there's also and I believe the Victims of Crime Commissioner would reinforce this, that anything that we want to do about communicating with victims should be on a consent basis and should be at the frequency that they want, when they want to hear updates, and therefore actually I think particularly in relation to those victim information schemes, there is a need for victims to say, yes, I want to be part of this, I want to receive this information, because some people will not want to receive that information.
Yeah, but Julie, what you're saying is that if you're a victim before the trial, you don't have to sign up to anything. You're just going to get the information. But as soon as the trial's over, then you do have to sign up. I'm not quite understanding it. That there's a sudden block and everything changes the moment the trial's over. To me, it doesn't. In my head, it's a continuation. And therefore, if we're talking that people should only get the information the frequency they want before the trial, but we're saying, well, they don't have to sign up to anything, we're just going to give them that information. But post-trial, you have to make the physical decision to sign up to the victim information scheme. I'm not saying how that's joined up.
I think the victim and information schemes are set in statute, and it is a statutory requirement that individuals register for them. I don't have operational responsibility or policy responsibility for those schemes, so I can't speak to the detail of them. What we're saying is that victims have told us that lots of things about how they're communicated. They've told us that the communication can be oblique. It can be hard for them to understand. They can be waiting. They can be expecting updates that they're not receiving. So I think there are challenges for us as a system, and as a system with individual organisations within that, to look at how we engage with victims, to make sure that we are, in the first instance, doing all of the things that we should be doing under the charters. In the second instance, looking at when we do communicate with victims, that we're doing that in a trauma-informed way, in a way that is accessible. When we are communicating, that we're managing their expectations so that they have an idea at the start of an investigation at what points they're likely to hear information, so that they understand what's going on and when they're likely, and so they're not thinking, have I been forgotten about? They'll have an understanding that, well, actually I'm not expecting an update, and that as part of that, and this is something that the Commissioner Designate has pushed for, that we don't have in place yet, but that we will want to work towards, that as part of that, at the beginning of that process, we should be saying to victims, look, do you want to have updates, or do you just want to know when something's changed? Do you want to, so it's about kind of moving where we are currently to a place that better suits the interests and the needs of victims and of individual victims, because not everybody is going to want to have regular well, actually nothing's happening in your case kind of updates, or there's no news. But some people will want that. So we need to work towards that. So that's some of the things that we want to do under that information and communication piece. How we communicate, how often we communicate, and how we take on board the views of victims. But currently the requirement, I understand the requirement to register for those victim information schemes is set in statute.
Yeah, and look, Julie, everything you've explained to me makes sense to me, but it still means that once the trial's finished, there is a demarcation line. There is a difference before trial, during trial, and then afterwards it's very different. That's the reality. And I'll put my cards on the table. I think the system for the Victims Information Scheme, from the moment they become a victim or a witness, should be a case of opt-out as opposed to opt-in. And I've said that for an awful long time. And I actually accept the point that you say that some people don't want that information, well then they opt out. But there's an awful lot of people who are traumatised by the crime that's been perpetrated against them as a victim, and they don't even think about signing up to any form of a scheme to make sure they get information. So I'm slightly concerned, and I'll be honest with you, I am slightly concerned that for me in my head, a victim is from the moment they become a victim all the way through the criminal justice system to the trial, and then post-trial when they get picked up by the probation board victim unit or the PPS victim unit or the PSNI victim unit. You know, there's so many victim units, care units out there that there's a degree of duplication, and it doesn't feel very joined up. I'm not going to labour it anymore, Julie, but I'm just say to you now, I am slightly concerned that doesn't seem to be a system that flows all the way through from start to finish. Sorry, thank you, Chair.
No problem. Connie?
Thank you for coming in today. I really wanted to talk about the development of this strategy, and obviously we had the previous strategy for victims and witnesses of crime. I think that was 2021, 2024, then 5, and how that was evaluated, where things had to be brought forward, or the things that worked well from that or didn't work well that you had to relook at in developing this strategy. And I'm also interested to hear how this strategy has linked in with other departments and other government strategies that focuses victims, and I'm thinking of those that would sit under the Executive Office, Department of Health and Justice for the domestic and sexual abuse strategy, but also the violence against women and girls. And how have you been able to link in with those strategies to make sure that everything's aligned?
Okay, no, well, on the domestic and sexual abuse strategy, and I would be the policy lead for the department, so there's that kind of continuity, and again quite a lot of continuity across both strategies with our partner organisations and the victim representative organisations that we would work with. So there's that kind of looking at how they both interact, and across. I have 3 teams within the department, so across those 3 teams there is that kind of looking at what, for example, we're doing in terms of, if I give the example of the Victim Needs Assessment Service that we want to bring forward, under the Domestic and Sexual Abuse Strategy, we have provided advocacy services for high-risk, high-harm victims of domestic and sexual abuse. That Victim Needs Assessment Service, we would want to then be providing almost like a safety net for people who aren't being referred into that, but there is still some sort of support there, and that Victim Needs Assessment Service, once in place, can also be a kind of, looking to see whether actually this person who's been referred to this service actually should be referred to into the advocacy service. So the intention is to have a joined up system, that holistic system that will provide services and support for all victims of crime. So there's that kind of level of continuity and thinking across the strategies. Equally, with the domestic and sexual abuse strategy, for example, we have worked really closely with the Executive Office to make sure that there's alignment there with the Ending Violence Against Women and Girls strategic framework. So there is, I think, a real benefit in having the same policy teams kind of having that helicopter view across those, and also then looking at, well, where are the other touch points, for example, speeding up justice and making sure that, whilst the victim and witness strategy isn't including or duplicating the work under that speeding up justice strategy. We recognise the importance of it, and where are the crossovers with what we're doing under a victim witness strategy, for example, in kind of that piece around communicating with victims and managing expectations. I probably lost the trail of the question, but do you want to come in?
I can maybe help on the reviewing the performance
Yeah.
of the last strategy. We did publish a performance report setting out what we'd achieved in the last strategy. And we took from, and then that's really what was the basis of our call for views. So that was the first stage of our engagement. And we sought views on what we were taking forward and feedback on what we could do better, and that then formed the next stage, the full consultation. So each time that when we went out with a new draft strategy, that was built on again in our draft strategy when we went out to full consultation. So there was a performance review of what was working well, and what we should continue to do. And in terms actually, and we did engage at a very early stage with across our own department, anybody dealing with any strategy and within Department of Justice, any strategy that may involve victims and having victims at the end of that, as well as across all NICS departments, to make sure not only that we were taking on their views, but they were aware of what we were doing.
Yeah, and I know the department's also consulted on, and the Minister plans to bring forward a Victims and Witnesses of Crime bill. Now, obviously, the department and the Minister are hopeful that will pass in this mandate. How will that affect this strategy that you put forward? Will that need to adapt if the legislative context changes throughout the course of the strategy, and how have you planned for that?
Yeah, so the bill would be a big enabler for a number of the measures that we want to deliver under the strategy. If the bill were not to get through, then within this mandate, then that would delay some of the measures that we want to bring forward. And obviously, within a new mandate, we would need to bring those back to the Minister to ensure that they wanted to proceed with that. But that bill is intended to deliver new protections for victims of crime that are intended to kind of deliver against those pillars of the strategy. So, if we weren't to be able to complete that bill within this mandate, the Victims of Crime Commissioner Designate would continue. So there would be some interim provision. There would be some things that we wouldn't be able to achieve, but for a lot of them there will be some kind of interim measure. So, for example, we want to, as part of that bill, introduce legal representation, third-party legal representation for victims of serious sexual offences at the pre-trial stage. We would not be able to do that without the bill. However, there would be some provision in that we already have SOLAs who provide legal advice and some advocacy to PPS, but the full ambition wouldn't be achieved without the bill.
Thank you. If you don't mind, one more quick one, Chair, if it's okay. I think we've seen strategies from executive departments that have the biggest impact and the most buy-in are those which have like elements of co-design and co-production. And on that, I think I'm really keen to hear how you've engaged particularly with victims, but also children, because being a victim of a crime can be horrendous for anybody, but I just really think in particular when that happens to a child or a vulnerable person, that can be really difficult. And how have you been able to ensure the voice of the child is heard in the work in this strategy?
Okay. Do you want to pick up?
We engage mainly with representatives of victims and representatives of children, and that gave us a lot of information for the strategy. We tried to engage with the Youth Assembly, but we weren't able to through timings, and we got valuable feedback, say for example from the likes of Nikki, who were able to give us a good children and young person's perspective. So the main extent will have been through NSPCC Young Witness Service, victim support through the Commissioner and the Commissioner's office, to really get feedback on the experience of children and young people. But we know it's important, but we did everything we could to try and get that voice heard, and through the system and also through the consultation processes. There were other representation or representative organisations through the call for views, through the consultation, who fed back to us, and as well as then any feedback through public comments.
And I think also then it's not just job done, at the point where the strategy is published, but actually how we continue to engage and how we actually strengthen the engagement mechanisms that we have. So one of the things that we want to do is seek victim feedback. That was previously done through the Northern Ireland Victim and Witness Survey, and which we're working to find an alternative mechanism to get victim feedback throughout the course of their journey through the justice system and at the end of their journey through the justice system, but also through focus groups. So we're looking at what that mechanism will be, and as part of that we're engaging in a workshop with children's representatives to look at how do we make sure that we can capture the voice of children and engage with children, and do that kind of feedback piece with children who are victims and witnesses, where they want to engage in a way that is safe, in a way that isn't intrusive. So, and I think we do need to very carefully think through how we do that, and that. So engaging with children's representative or children's organisations is really important, because I think we really need to get that right.
Thank you. Thanks for coming.
Okay, just before I bring in the Deputy Chairperson, Emma, can I keep you on Connie's point around the Victims and Witnesses Bill? Mm-hmm. Because within your actions and your strategy, you use two types of terminology. You say that in some actions you're going to implement provisions of the Victims and Witnesses Bill, which is very clear and concise. But then you also use terminology that states you're going to legislate to improve victims' experiences. So you don't mention the Victims and Witnesses Bill in that terminology, but you do have a timescale of 1 to 3 years. And really, the Victims and Witnesses Bill is the only show in town. So when you use the terminology legislate to improve, does that mean it's going to be included in the Victims and Witnesses Bill?
So we believe that the provisions in the Victims and Witnesses Bill will improve victims' experiences, victim and witness experiences, and that's why they're there. Now, some of how we intend to do that is through things like changes to not changes to the disclosure system, but some enhanced protections for Article 8 rights of victims of serious sexual offences, whilst not compromising the Article 6 rights of the defendant. So there's things in there about the disclosure process, which would make a difference to, and we know because it's come out in the Gillen report, victims have said that is something, victims of serious sexual offences have said that this is a traumatic experience. So that's about redressing that balance a bit. And we believe that will make an improvement to those victims, but also things like putting a requirement, a statutory duty on organisations that have obligations under the charters to report. So where you have to report on your compliance, that will drive, we believe, will drive improvements in compliance, and those improvements in compliance are intended to improve the outcomes and the experiences of victims and witnesses. So when we say, so it is tied to the bill, essentially, we believe those provisions they're there in order to improve victim experiences and witness experiences.
Well, irrespective of the terminology, everything here that deems it needs to be legislative in this strategy is going to be brought in via the Victims and Witnesses Bill.
The strategy is 6 years and our action plan is 2 years. So we're saying within our action plan, the legislation is the Victim and Witness Bill. We see this as the strategy and the action plans will evolve. There will be emerging issues. So I can't say that everything under the strategy that needs legislation will just be in that bill. There may be something down the line where there's a legislative requirement.
Well, if it's not the Victims and Witnesses Bill and you put a 3-year time frame on it, what other piece of legislation is there?
At the minute, it is just the Victim and Witness Bill. I'm saying that in the space of 6 years, there may be something further down the line.
Okay, thank you. Emma?
Thank you. I just want to focus on the rural crime element, and I know that there was reference to engagement with rural communities. I wonder how much of that has happened, or who you have consulted.
I think that was one of our most successful areas of engagement, in that it was something that was entirely new to us, and and eye-opening in terms of the detail. We met with a large group, it was the Cookstown community group, and they had a really widespread representation at it, and they brought to our attention a lot of issues which we've brought back into the strategy, and we plan to keep engaging on that, and we plan to keep engaging specifically with that group. So does that answer your question?
So it's just ongoing.
It started it in the sense that through our consultation it informed the new strategy, and it's ongoing because it's now embedded in our action plan and our performance framework, that we will continue that engagement with them, listen to their views, and we've invited them to what we hope will be our launch on the 11th of March in order to keep that conversation going, and that's something we have threaded throughout the action plan, and that engagement not just with the rural community but those harder to reach groups that we maybe have now got contacts with for the first time, that we can continue that engagement.
Is there a cross-border element to that?
They raised cross-border elements, yeah, in the sense that some of the crimes that they were dealing with, particularly, for example, around the Fermanagh Lakes issues, so they did raise those, and we have, in our contacts with colleagues in Dublin, we have put them in contact with colleagues in Dublin since then.
Okay, but it's not coming from the department?
What's not the...
So in terms of like the rural crime that would be brought to my attention as a rural representative, you know, like if machinery or livestock are stolen, one of the, I suppose, outcomes of that is very often that those items, for want of a better terminology, ultimately end in the 26 counties. And one of the problems that's flagged with us is that there isn't enough engagement between the distinctive bodies on both sides of the border. So
particularly on those rural crime issues. Yeah, drugs trafficking was a big one that came up for us.
I think there are likely to be some things that we'll need to get into the detail of in relation to the victim witness aspects, and there may be other aspects of those kind of issues that other policy teams, in terms of the kind of operational response, would need to look at. But I'm happy to kind of take it away and look at it.
Thanks, Chair.
Brian?
Thank you, Chair. Thank you for your answers so far, and I'll have to give apologies for the lunch. I have a Finance Committee on a Wednesday afternoon, but I don't know if there's a pre-part to the lunch. I'll attend that in the Long Gallery beforehand. So if I was to ask you what's new in the new strategy compared to the previous 3 and 1 year strategy, is there any... Do you think there's any particular development? I know a lot of work will have rolled forward, but if you had to say there was particular headlines, what would you point to?
For me, the bill is new, and I think it's really important. And it's things that we've wanted to do. So the bill, which in a way it's new, but it's also following on. It's growing from things that we were in the last strategy. So it's taking that kind of desire to be better at complying with the charters and saying, well, now you're going to have to report on it. So that's new. I think the Victim Needs Assessment Service, which is subject to funding being made available, but I think that is something that we've wanted to do for a long time. We haven't had funding. We are actively bidding for funding, but we haven't got a decision on that yet. But that is, I think...
and what would it sit within? Because I'm aware you have the Victim Witness Care Unit within PPS, and then your Victim Support NI, which I presume is more voluntary sector. Is it?
Yeah. So I
always wonder. I appreciate there's different roles, but sometimes the whole system can seem more and more complicated to...
And I think the Victim Needs Assessment Service is intended to try to help uncomplicate it. So the Victim and Witness Care Unit is run by PPS and police, and it's largely about communicating information about your case, etc. to once a case is passed to PPS. So it is quite factual. Victim support provide a range of support services to all victims of crime, and we fund them to do that. So the Victim Needs Assessment Service would try to bridge those functions really, and from the point of a report of crime, begin to engage with the victim to assess their needs, to be asking things like, how often do you want us to communicate with you, to be looking at, well, what are their needs in terms of the trial, but also to be looking at more holistically at what those needs are and to be signposting them. So providing not just factual information, but providing actual real support and signposting to other organisations where they don't have that support in-house. And the vision that was originally recommended by Sujini was that would be bring together victim support with PPS and police, so it would kind of be bringing the care unit role and the support role together to provide a system that will stay with, or a service that will stay with the victim throughout their journey as their needs may change as well, and just to kind of to take out some of the complexity of the system.
Mm-hmm. So, will victim support as we know it still exist then? Yes?
Yes.
Right.
We would see victim support as being a delivery partner in this, and that was the vision in the Sujini recommendation, but they have a wider role, so it wouldn't just be, they are providing support services. So part of that, I think Victim Needs Assessment Service is likely to be kind of a branch of that would refer into other services that are provided by victim support.
And Victim Needs Assessment Service, would it be, though, in its nature, a statutory service or delivered through a voluntary?
It would be delivered we need to work out the model. There was a lot of work previously that was done on a model, and we need to go back and review that because a lot has changed, since. But it would be, I think, a partnership between statutory agencies and victim support. So it would involve them working collaboratively. So bits of the Victim Witness Care Unit working with a Victim Needs Assessment Service alongside, and funded by the department.
Okay, so I interrupted you with the headlines, or are those the main two you would point to, or?
Well, under the bill, I think
the assessments.
One of the big things I think under the bill is the establishment of a statutory Victims of Crime Commissioner. So we have a Commissioner designate. This would give powers to a statutory commissioner, and duties placed on organisations with charter obligations to be reporting against those, and then also the provisions that relate to disclosure and to third-party legal representation as well. And there will also be hate crime provisions in it. And the other thing that we're working with health towards is the development of a Barnahus model, and we were working. We have a Barnahus model, right, which means child house, and it's an Icelandic model for providing wraparound services for children who are victims of sexual offences. So wraparound healthcare and justice services, and so we've been working with health and other partners and voluntary sector to look at, well, what would a model for Northern Ireland look like? The thinking on that is quite far advanced, and we would hope to put recommendations on a high-level model to ministers in coming months. Is there anything more you would say on that?
Just a bit of an update on that. Yes, we hope to send options to both the Justice and Health Ministers. We're aiming to do that by June. Yesterday we had a further workshop on the Barnahus model, bringing together a range of stakeholders from voluntary and community sector, and statutory organisations, and that was to again look at those various options to make sure we've fully analysed and evaluated them. The next step then will be to identify those high level costs so that we can go to ministers with proposals.
Okay. Okay. I'm going to ask a question from the other point of view. In terms of the complexity of the criminal justice system generally, I mean, do you see any opportunities for making it less complicated and making savings? Every time we add another layer, which no doubt is well intentioned and will provide more support, but is there any opportunity for where savings can be made, where services can be brought together?
I don't know that it would be savings. I think what we would want to do is avoid duplication.
Yeah.
Victim Needs Assessment Service will be a new service and it will cost money. But what we don't want is for it to cost money by doing something that's already been done. And that's why we do need to look at how it will dock into the existing supports that we have, and rather than replicating those. Even if those supports are being delivered by a different organisation, they need to be able to dovetail together, and so that's the vision that we want to achieve, is that there is cohesion across the system, that we're not creating needless additional cost. But I think to deliver what we want to deliver under the strategy, there will be cost attached. I don't think it's about savings.
Well, it's about avoiding duplication. I agree. Yeah. But one other question, Chair. That's okay. In our notes, committee notes, it highlights about transcripts of sentencing hearings, a rollout of that. I can't find it actually in the strategy. I thought it might have been in the third pillar on transparency and participation or community, but I can't actually find it at the moment. But
I think the strategy is high level, and a lot of the detail will sit within the action plan rather than so the strategy will set out this is what the objective is that we want to achieve, and then the action plan is setting out, and here's the thing that we're going to do to do that. So it is in the action plan.
Okay.
Yeah, there's an action plan.
Okay, and we've raised this before in terms of transparency in the justice system. So can you say a bit more about how that will be rolled out? Will certain cases, types of cases, will it start with certain perhaps more serious cases, or
the transcript?
Yes, transcripts of sentencing, sentencing remarks, because I think we agree quite often, especially if there's guilty plea and then the victim doesn't actually hear. And that's part of the closure process for them, I think, hearing judges' comments.
We would plan to run a pilot scheme of that first. So work still has to be done to figure out what cohort we would look at first. I know in England and Wales they have focused on rape and serious sexual offences. In the action plan we haven't narrowed it down as such, but it's something we will look at when we're progressing that pilot.
Okay, and is there a start date for that? Or?
I think it is in I'm not sure, I know it's in the first two years of the action plan, but yeah.
Okay, thank you, Chair.
Okay, Aoife?
Yeah, thank you, Chair. Look, one of the major problems with victims of domestic abuse and sexual offences is how they're treated in court. And it's all too regular that a victim's sexual history or information about their private life is weaponised to discredit or humiliate the victim. So when the strategy talks about Pillar 4, about new legislation to protect victims, what will this legislation be and when will we see it?
So that will be one of the provisions in the Victims and Witnesses of Crime Bill, which will legislate in relation to the disclosure regime, and will also make provision in relation to third-party representation for victims in serious sexual offence cases. So the intention is to not to prevent an application being made for disclosure because the defendant has has a right to a fair trial, but to create a statutory process whereby defence will need to set out timeframes, show the relevance of the information that they're seeking to be disclosed, and then it will go before a judge to consider that either on the papers or in a pre-trial proceedings. So it's not about it's absolutely not about removing the right to seek to apply for third-party material to be disclosed, but it is recognising exactly what you said, that that this, we know that this is traumatic for victims. We know that in many cases the relevance isn't shown. We know that it contributes to attrition, and that came out in the Gillen review. So it is addressing those kind of things by rebalancing and seeking to protect the Article 8 rights of the complainant, but not at the expense of the Article 6 rights of the defendant, which are absolute. Do you want to say anything more?
Just to add on to that, on the independent legal representation for complainants. So complainants in serious sexual offences cases will have a right to that independent legal representation, and that will be at specific pre-trial application hearings. So it'll be for pre-trial applications for third-party material disclosures, that could be counselling records, and also applications by the accused to admit evidence about the victim's sexual history at trial.
Thank you very much.
Okay, Ciara?
Okay. Thank you, and thank you, ladies. I'm always impressed with you ladies, because you brought forward a strategy which is really positive. Stakeholders have come forward and are quite positive with it. So well done. And likewise, the Barnahus, I was going to ask you a key question on it. So Emma, you've answered it. I'm delighted that obviously recommendations will go forward, because it is the gold standard, I think, and particularly for our young people. So I'll keep an eye on that, but that's good to get an update on that. So I'm just going to be a wee bit more difficult with these, right, on this one, because I know it's a difficult one to answer, and you probably can. So you did mention previously regarding a lot of work and aligning with other strategies within departments, and I know that can be really complex because this does overlap other departments, but just in relation to the approach now and identifying their gaps, because there is key gaps on social care, housing provision, education, to provide better support for victims and witnesses. How you're going to do that, you're going to need loads of buy-in from other departments and resourcing, I would assume, with other departments. So what kind of work at the minute, and I know that's going to be the hard nut to crack, in relation to putting the investment in and liaising with the other departments to try and seek buy-in and likewise resources. So I know that's a difficult one, but just where he's at in that. So.
I think some of that will need to be discussed at executive level, and I think when we consulted on the commissioner role, we said, like, we're not, the commissioner's role is intended to be for justice, and that's what we're planning to legislate for, but we anticipate that, in future we would want to look at, and we consulted on, was there a wider role for looking at wider kind of victims' issues that went beyond justice. Within our victim and witness steering group, and they've contributed to the development of the strategy, so Department of Health is represented, and that is recognising, first of all, that there's a huge health and social care role in relation to particularly domestic and sexual abuse, but actually other wider victim issues and mental health, and the health and mental health kind of implications of crime and the impact of crime on victims. So they are represented. We also have said in the strategy and the action plan that we want to look at the starting point for this is quite small. So it's about kind of how do you financially support people to turn up at court, and currently my understanding is that PPS will have a fund that, so if someone's travel expenses will be met, but they claim it back. So we want to look at that, because in some cases actually claiming it back isn't appropriate. They need the money in order to get to court. But the starting point was, we're going to review that, because that's quite a small issue, but we want to look at it. But then whenever you start to look at it, well, then you look at, are there other similar impacts then, just by attending court for a victim that justice isn't responsible for, but say, for example, an extra day off work, in order to, does that affect someone's earnings and things like that? So I think, in answer to your question, I don't have the answer to your question, but we recognise that there are really extensive needs and interests of victims that go beyond the Department of Justice responsibilities, and we recognise the need to be engaging, and we've said that we're going to start that with that piece on the financial support for attending court. We've got Department of Health regularly engaging and being represented on the steering group. They're also represented on domestic and sexual abuse oversight board, as are the Department for Communities and Education. So we have some work that's ongoing. We recognise that there's a greater need, and we also think that there's a role for the Commissioner in highlighting and driving and some of those issues, not in delivering those issues, but in highlighting them and pushing us, really.
I think as well there's something around highlighting the fact that a lot of maybe policies in other departments, you mentioned education and housing, there are victims at the end of there somewhere, and people don't often see that, so there's something around raising that awareness.
Yeah, okay. Thank you.
Okay, no further members have indicated then to ask questions. So Julie, Emma and Joanne, thank you very much for your attendance here today and your time and your answers. Thank you very much.
Thank you. Bye-bye.
Okay, members, we will push on. We are struggling for time. Agenda item number 6 then is SL1, the Police and Criminal Evidence Northern Ireland Order Codes of Practice Order 2025, Department of Justice Oral Evidence. Refer members to pages 168 to 765 of the meeting pack for the relevant papers. Can I remind members that the Department of Justice proposes to make a statutory rule under powers conferred by the Police and Criminal Evidence Northern Ireland Order 1989 PSNI. The rule is subject to a negative resolution procedure. Members will be aware that the committee has been considering the revised PACE codes in detail over the past year, in particular with regard to Annex L of PACE Code C. Concerns have been raised about the rights of transgender detainees and whether an officer could be forced to conduct a search against their wishes or face detriment to their career if they refuse to search a trans detainee. The department had been asked if a no detriment safeguard and or the National Police Chiefs Council's NPCC guidance could specifically be incorporated in Annex L. Can I remind members that on the 11th of December, members considered the Department's response advising that the inclusion of a no detriment safeguard in the PACE codes is not possible as it is an operational HR issue for the PSNI and would not be within the legislative scope of the PACE code. The departmental official in attendance at the meeting advised that although the reference to the NPCC interim guidance could not be included within the codes, it could be referenced in documentation to be published alongside the codes, and the department would provide a draft note for consideration by the committee. Can I inform members that the department has now provided the committee with that draft note, which is at pages 179 of the pack. The department's correspondence also notes that the PSNI had advised that there would be benefit in providing greater clarity at paragraph 5 of Annex L with regards to the consent required for different types of search. The revised Annex L is included in the meeting pack and begins at page 180. Can I inform members that Lisa Bowe, Head of Police, PACE Policy and Legislation Branch, is present at today's meeting to provide any further information or clarity on the matter that members may wish to raise. Thank you very much, Lisa. You're very welcome to the committee again. Can I ask if you have any presentation to give?
No, nothing further to add. Just happy to take any queries from members.
Questions? Okay. I'll start. I suppose, first of all, can I acknowledge the progress that has been made? Can I applaud the clarification around the new paragraph 5, where it goes into detail around the various searches and who would conduct them? And also the fact that in paragraph 5 it says that in all circumstances, and it's highlighted in bold, it must be recorded that the search has been conducted following a consensual regime. Can I also place on record the advancement with regards to the MPCC guidance and the fact that it's been incorporated, if you like, with regards to the Annex L and the new draft note? and in that it's very clear that there will be no career detriment to the officer or members of staff, both in an officer conducting a search or refusing or not consenting to a search on a detainee who is trans, but also a trans officer won't. There will be no detriment there with regards to them also. Can I say that whilst we note the progress, we are still concerned, and I mean my party colleagues and I, that you still can't put on the face of even the draft note that runs alongside the PACE codes that there would be no detriment to a police officer. And I'm wondering, Lisa, why is that when we go into detail around the recording of the search and that being consensual, which I believe is operational, why can we not add a line in paragraph 5 that states that there will be no career detriment to the officer or member of staff? Why can't we just lift off what it states in the MPCC and insert it into paragraph 5 of the accompanying note? Although it's deemed Annex L, why can we not have that in there?
You can't put it in Annex L because Annex L is part of the PACE codes which are around the treatment of individuals held in custody. We could include it in the draft note published alongside the codes if that would be of any help.
Could do that?
Yeah.
So how would that read? Or if I
would need to work on some drafting, but we could just to get the flow of the paragraph, but we could look again at the draft note and take on any comments that members have on that draft note.
Yeah.
Happy to do that.
If that word, if that terminology of that there be no detriment to the officers, and we don't have to even name female officers, it can be officers.
Yeah.
If there's no detriment, there will be no detriment to officers if they do not consent to a search. I think, not having seen the text, I think me and my colleagues would be content with that.
Yeah, we can include wording to that effect in the draft note that will be published alongside the
which would be published alongside the
Yeah.
Annex L, which would be published alongside the PACE codes.
Yeah. It'll all be published together.
Is there any other comments from other members? Doug?
Yeah, can I just ask, when you talk about the notes, because the notes are notes for guidance, and yet in Code C, page 275, it clearly states provisions of this code includes annexes, but does not include guidance. Could you just clarify that for me? Because a note is guidance, and therefore it won't be included.
Yes, we're publishing a note alongside the PACE codes to explain where we are and how we're responding to the Supreme Court judgment. But even the notes for guidance in the PACE code are around notes for guidance in terms of the application of the PACE codes and how they relate to individuals.
But the notes for guidance won't form part of the code. It's only guidance, and guidance doesn't form part of it. The language just seems a bit ambiguous for me there. That's all.
Yeah, but what I'm saying is, the note that we'll publish alongside the PACE codes will make reference to the MPCC guidance, and that there will be no detriment to police officers.
Yeah. Look, I'll need to see it and understand it, because I just don't at the moment. Thank you.
Mm-hmm. And just to clarify, Doug, on your point, and to Lisa, it wouldn't just be referring to the NPCC guidance. It would actually be, the terminology would be in the note.
Yeah, in the note that we'll publish alongside the PACE guidance that we've shared the draft, that's it, the drafted Appendix 1, where we've said that the PSNI has adopted the NPCC guidance. We'll say that makes clear that any officer who does not consent can do so without any career detriment. Yeah.
Ciara, you wanted in?
No, it's just to reiterate and put on the record once more that we as a party do not accept codes H and I for the detention and question of detainees. It is draconian legislation, it's Westminster legislation, and we believe it's in breach of the human rights of detainees. And I know we've reiterated that before, but it's just to put it on the record.
Yep, no problem.
All right.
Any other comments further to what has been stated? Can I ask them one question, because it's a point that Doug does raise. So, if the courts are looking at legislation, they can also look at the white pages of a bill, the memorandum,
I think so, yes.
Yeah, so what weight would an adjoining note have, let's say, in a court of law, if there was a challenge to be made?
To be honest, I'm not sure. I think that would be a matter of obviously for the judge or whatever, and obviously that's judicial independence, and obviously they would. I can't comment on that. I wouldn't, that's not my area of expertise.
And it's clear. Sorry, Doug, you want back in again? Go on ahead.
Yeah, so this is fundamentally the problem that I'm talking about, Chair. So if you go to page 275 and you go to paragraph 1.3, provisions of this code, and it will say, do not include notes of guidance. And that's what we're talking about here. We're talking about adding the MPPC as a note of guidance, and it said it doesn't include it. So a judge for me would then be able to disregard that.
We're not adding the NPCC as guidance. We're referring, in the note that we're publishing alongside the code, we're explaining that the PSNI has adopted that guidance and that guidance makes provision for there to be no career detriment.
Yeah, and I guess if you take away the word guidance and just use the word notes, as far as what Annex C, what Code C says,
The Annex L.
if you take away the word guidance, it just notes. So notes will not be part of the code.
Yeah, the notes are there to sort of aid interpretation of the content of the code.
Yeah.
So they don't actually.
I mean, I'll be honest with you, Chair. I'm finding it really hard to explain myself.
Yeah.
But it's.
So I suppose they don't actually, the adjoining note for guidance doesn't actually make the text of the legislation or the law, but they are adjoined to the law as guidance with regards to interpretation. That's how I see it. But you're right to question the greyness of that and the fact that you've alluded to that page 275. So I suppose, Lisa, if we can have any sort of reassurance with regards to Doug's point, I think that would be helpful to come along with. But I do note the progress. You understand our concerns all along here with regards to a police officer, and it's basically this: a very busy shift. There are police officers running about all over the place. Somebody's been detained. They require to be searched. There has to be consent from all parties: the detainee, the duty officer, and the person conducting the search. All have to consent. But if that person has been detained as a trans and they want to be searched by someone from their lifestyle, then if there's only one female officer in the station and there's no other female officers involved, the pressure that would come down on that person could be immense. Mm-hmm. And that's why we've been very, very strong on this detriment piece. Because in the best will in the world, whilst you can't make someone do something and it states that in the MPCC, the pressure that would be brought to bear on that individual to conduct that search, even though they wouldn't want to, could be mighty.
Yeah, I understand that concern.
Yeah. Okay, if there's no further commentary then, or questions on that, Lisa, thank you very much. I hope we've been able to clarify our position, both as a committee and as individual members.
Yeah, so in terms of just the next steps, if we come back with a revised draft of that note, then we can
Yes, absolutely.
We can table that for a decision then.
Yeah, we look forward to seeing that. Okay, thank you very much, Lisa. Yeah. So, members, I'm going to park that then and not ask the question until we see that. Everyone happy and content with that? Okay, agenda item number 7, Justice Bill written papers. 7.1, copy corresponds to Claire Hanna MP regarding the Children and Young Persons Act 1968. I refer members to pages 767 and 768 of the meeting pack for the relevant papers. Can I inform members that the committee has received further correspondence from an individual regarding the response to the committee's Justice Bill call for evidence? The individual has expressed thanks to the committee for forwarding their previous correspondence to the Department of Health for response and for issuing them with the Minister's response to the matters raised within that correspondence. In this latest correspondence, the individual has forwarded to the committee their correspondence to Claire Hanna MP and advised that they have been unable to make any progress in their approach to Ms Hannah in relation to their query to her about the Children and Young Persons Act NI 1968. Can I ask members if they are content to note the correspondence, or if any further information or clarification is required at this time?
Noted.
Okay, members, before we move on, can I then just add into the record the stuff that we have agreed to do with the Justice Bill earlier on in our informal deliberations? It was agreed with regards to the amendment on the review of the use of live links, and that we would ask the department to take that forward. Formal wording was agreed, and that we had then asked for the department to take that forward. Another aspect was we agreed to consider an enabling power for photographs and other emerging technologies with regards to the biometrics measures. We agreed to include the word vulnerabilities in Article 39, Article 482A and Article 10H. And we agreed to write to, as amendments, and then we agreed to write to Department to clarify the power to remove information from Biometric Commissioner's reports, and that's at 63Z15. And then also we agreed to write to the Minister of Justice and to the Minister of Health regarding the accommodation piece in Clause 8, and why we're still a wee bit aggrieved with regards to that not being commenced in the bill. And we understand the reasons why and the rationale for that, but we really do want to see progress made there. Are members content with that? Cathy, have I missed anything out, or Thomas?
I don't think so, just that the committee will wait until it receives a response from the department on restorative justice and the sanctioning aspect, and about the review mechanism for youth custody and supervision orders before it makes any decisions there.
Yep, okay. Are members content then? Proceed then on. So agenda item number 8 then, SR 2026/12, the Rehabilitation of Offenders Exceptions Amendment Order Northern Ireland 2026. Can I refer members to page 770 of the meeting pack for the relevant papers? Can I inform members that on the 3rd of February, the Department laid Statutory Rule 2026/12, the Rehabilitation of Offenders Exceptions Amendment Order Northern Ireland 2026. The rule is intended to address the potential safeguarding gaps regarding the delivery of adult restorative justice initiatives and with respect to self-employed individuals whose role requires them to work with vulnerable groups. The SR will make provision for new exclusions under the Rehabilitation of Offenders Exceptions Order Northern Ireland 1979 in respect of individuals whose suitability is being assessed for the purposes of delivering adult restorative justice interventions, and B, individuals undertaking a self-employed personal employment role with vulnerable groups. The rule is subject to a negative resolution procedure and came into operation on the 17th of February 2026. Can I remind members that the committee agreed that it was content with the SL1 for the rule on the 15th of January 2026, and the department has confirmed that there have been no policy changes to the content of the rule since the SL1 was considered by the committee. Can I advise members that the Examiner of Statute Rules did bring the rule to the attention of the Assembly in her 56th report, as it was laid in breach of the 21-day rule. The department has expressed regret, but confirming that the regulations were laid in breach of the 21-day rule in order urgently to ensure that identified safeguarding gaps did not persist, and the examiner states that she is content with the department's explanation. So can I ask members then if they are content with the statutory rule?
Yeah.
If so, then I'll put the question that the Committee for Justice has considered SR 2026/12, the Rehabilitation of Offenders Exceptions Amendment Order Northern Ireland 2026, and has no objections to the rule. Agreed?
Agreed.
Agenda item number 9 then is SR 2026/13, the Police Act 1997 Criminal Records Amendment Regulations Northern Ireland 2026. Can I refer members to page 791 of the meeting pack? Can I inform members that on the 3rd of February, the Department laid Statutory Rule 2026/13, the Police Act 1997 Criminal Records Amendment Regulations Northern Ireland 2026. This rule creates provisions for eligibility for enhanced checks under the Police Act, Criminal Records Disclosure Regulations, Northern Ireland 2008. For three aspects. One, considering an applicant's suitability for becoming a practitioner for the purposes of delivering restorative justice interventions. Two, inclusion of a check of the adults barred list for this role. And three, removal of the age restriction 16 plus for enhanced checks for those whose home is used for provision of hosting guests under the Homes for Ukraine scheme. The rule is subject to the negative resolution procedure and came into operation on the 17th of February 2026. Can I remind members that the committee agreed that it was content with the proposal for the role on the 11th of December 2025, and the department has confirmed that there were no policy changes to the content of the role since the SL1 was considered by the committee. Can I advise members that the examiner's statutory roles did bring the role to the attention of the Assembly in her 56th report, due to the role being laid in breach of the 21-day rule, as well as for the drafting error in Regulation 2.4 of the regulations. The department has confirmed that the error will be addressed by correction slip at the earliest opportunity, and the examiner is content with this approach and with the department's explanation for its breach of the 21-day rule. So can I ask members if they're content with the statute rule? If so, I put the question that the Committee for Justice has considered SR 2026/13, the Police Act 1997 Criminal Records Amendment Regulations, Northern Ireland 2026, and has no objections to the rule. Agreed?
Agreed.
Agenda item number 10 is correspondence. Can I inform members that there is a correspondence memo and 8 items of correspondence at page 800 to 979 of the meeting pack. Can I advise members that I will draw their attention to 3 of the items in the meeting pack, and then members will have the opportunity to comment on any other items of correspondence. 10.2, can I refer members to page 802 of the meeting pack, which contains a response from the Department of Justice to 2 items of correspondence that members agreed to forward to officials in relation to pro bono assistance for self-litigants. The committee had requested that the department address the general issues raised regarding pro bono assistance for self-litigants in the forwarded correspondence, as well as to provide an update on any work undertaken and progress made further to its previous response to the Committee for Ulster University's research on litigants in person in civil and family courts in Northern Ireland. I'm just going to get to that page in my correspondence. Before I move on, the department has simply responded to say that it recognises the difficulties faced by self-litigants and makes a general reference to ongoing work within the Enabling Access to Justice programme as a way to help address some of the challenges. Can I seek members' views on whether they consider the department's response to have sufficiently satisfied the committee's request, or whether members may wish to seek a more comprehensive response from the department? Folks, I don't think this is enough. It basically talks about our Enabling Access to Justice programme includes work aimed at improving access to early legal support. They haven't told us exactly the details around that work. This includes the forthcoming engagement exercise on measures to enhance access to justice and deliver better target assistance, as well as existing provisions such as a housing possession court duty scheme funded through the Legal Services Agency. I think they can go into much more detail on this. There's 2 people that have wrote to the committee, which we have then asked for a response. The department has sent us this. We could just pass it on to the people who have contacted us, and I just don't think there's enough detail there. And so I would propose that we write back seeking further detail on each of the work programmes that they have within their Enabling Access Justice and how it relates to pro bono cases and self-litigants. To me, this is a very important issue, because there are so many people out there, and it's a growing number of people doing self-litigant work. Are members content?
Yeah.
Okay, Kathy, have you enough there?
Yeah.
To go on. Then 10.5, can I refer members to pages 871 of the meeting pack, which contains further information on a number of matters that the Lady Chief Justice agreed to provide the committee with during her oral evidence session on the 22nd of January. The response advises that it is not the court's role to alert the Home Office to the release of foreign prisoners for deportation, and suggests that the committee may wish to write to the Prison Service for an update on the current position So can I ask members if they are content to seek this information from the prison service, and if there are any further comments on this? Doug, I don't mean to put you on the spot, but you had raised this with the Lady Chief Justice, I think. Do you want to come back with anything?
No, I'm happy enough. I've got some other questions into the Justice Minister in regards to it, so I'm happy with what she's replied with.
Okay, and you're happy enough for us to write to the prison service?
Yeah, more than happy.
Yep, okay, thank you. So are all members content then with that line of progress? Okay. 10.6 then is refer members to page 883 of the meeting pack, which contains an inspection report by Sagini into child criminal exploitation in Northern Ireland, how the criminal justice system recognises, assesses and responds to child criminal exploitation. This got a touch in the media yesterday. Can I inform members that the report highlights a number of gaps and concerns in addressing child abuse and the exploitation of children across the criminal justice system, and includes several strategic and operational recommendations? Can I advise members that as the report has been published, the PSNI and the departmental action plans to deliver their recommendations are available on the Sagini website. Committee staff will circulate copies of the plan to members for their information. But can I seek members' agreement to forward the report to the Committees for Health and Education for their information, as the Department of Health and the Department of Education were consulted as stakeholders in that inspection?
Yeah.
Could I also suggest, members, that we may consider a joint oral evidence session with officials from the Department, the PPS and the PSNI on this Sagini report and other matters around child criminal exploitation? I think it's a really important report. I think it also touches on some of the stuff that we've been doing in the Justice Bill and in other fields. Would members agree to that? Yeah. Would you also agree then that we maybe seek to get Sagini in herself to give us an update and to speak to the report and any other issues then, and we can make that a broader issue, a broader presentation? Are members agreed?
Yeah.
Okay, thank you, members. So can I ask members if they are content to note the other items of correspondence as set out in the correspondence memo in the meeting pack, or whether there's any comments to anybody want to raise anything from the correspondence?
Just one quick one, the 10.31 regarding DOJ response. They says they got helpful advice from the Human Rights Commission, and Human Rights didn't respond to the consultation either. So can we ask again, maybe, what was the helpful advice that the Human Rights Commission gave to the department, if that's okay? Okay,
I'm happy enough for that. Members content? Okay, agenda item number 11 is forward work programme. Can I inform members that the department's proposed forward work programme for March is at page 981 of the meeting pack, and the latest draft of the committee's forward work programme can be found at pages 982 to 987. This is an updated version of the department's work programme and replaces an earlier version which had two additional written briefings scheduled for the 5th of March, one on the review of the State Pathologist's Department and the other on the introduction of the Victims and Witnesses of Crime Bill. So can I ask members if they are content to schedule the proposed work items from the Department of Justice into the committee's forward work programme? And I note that they did say the day that the Victims and Witnesses of Crime Bill would be before June, did they say?
Yeah.
Yep. Okay, members content?
Yeah.
And then agenda item number 12 is chairperson's business. I can advise members I have no chairperson's business this week. Agenda item number 13, any other business. Can I ask members if there are any other items of business they wish to raise at this point? That's a no then. I'll move on. Agenda item number 14 is date, time and place of next meeting. I advise members that the next meeting will take place on Thursday the 5th of March 2026 at 2 p.m. in room 30 Parliament Buildings. The meeting adjourned. Thank you.